Yogesh Chauhan. And I hope I didn't mess up the name. I probably did. So Yogesh asks me actually two questions that are very similar. So I'm going to go through them both in this one video. First question is, what is the difference between a state trademark registration and a federal trademark registration? And the second question is registering a business name with a state the same as trademark protection? I'm Andrei Mincov, the founder of Trademark Factory, and here's my answer to this question. These questions sound similar, but they're actually about two completely different things. So first of all, this relates to US, right? Because only the US has different rules for state trademark registration and federal trademark registration. So first of all, the difference between getting a state trademark and registering your business name with the state, totally different things. Registering your business name with the state, it's like incorporation, or maybe registering the name of your partnership. It's telling them, I will be operating my business under this name. I want it registered. So that goes to the corporate registry of all the companies, all the entities that are doing business in that state. And that doesn't give you any trademark rights, because trademarks are not about your business name. Trademarks are about identifying products and services that you offer or planning to offer to the market. And sometimes the name of your product, the name of your service may be the same as the company name, but not necessarily. I mean, you can have a numbered company that sells a branded product. You can have one brand and sell completely different products. The example I always give is Apple, right? They don't have a separate company called iPhone Inc., right? So the name of the company, the business name is Apple, the trademark is iPhone. So that's the difference between registering a business name with the state and getting a trademark. Now, here's about the difference of federal trademarks and state trademarks. Typically, when somebody mentions registering a trademark, they're referring to the federal trademark. That's the trademark that you want. And the state trademark, well, is a trademark you register with the state. It's a weaker version of that. So let me walk you through what makes those types of registrations different. So federal trademark, as you probably can guess, covers you all around the US. Regardless of where people know about you, if you have a federal trademark, you can stop anybody in the entire country from using your brand without your permission to offer products and services that are identical or similar to yours. So that's what federal trademark does. A state trademark only allows you to enforce your brand within that state. So if you've got, let's say, a restaurant in California and you get a state trademark on that, then it's perfectly legal for somebody from New York to start a restaurant under the same brand, and he wouldn't be able to do much about it. Now, the territory, right? The second thing that's different is that you can, in theory, only get the federal trademark registration if you have interstate commerce, if you sell to not only people in your state, but also to people out of state. It could mean you having branches. It could mean you just having business to clients from different states or different countries. So you need to be able to show that to get a federal trademark. If you're so local that you're not planning to go outside of your state, then you might only get the state trademark, but the value of that is really limited. One of the things you cannot do with a state trademark is you're not allowed to put an R in a circle after your trademark registers, because it's a different procedure, it's different ways to enforce it, right? It's one way to enforce your federal trademark in a federal court, and you can't do that with the state trademark. Now, one thing you can do that you cannot do with the federal trademark, what you can do with the state trademark is register marijuana brands. So currently, marijuana is illegal on the federal level, so you cannot trademark marijuana brands for marijuana products. But some states make it legal, and for those states, you could get a state trademark. Again, the value of that would be quite limited, but it's better than getting nothing. There are different rules, different states have different rules for whether registering with a state gives you the presumption of ownership. Some states answer this yes, some states answer this no. So federal trademark does give you that presumption. It does give you an opportunity to claim that your mark became incontestable after 5 years. There's a lot of different things that you can do with a federal trademark that you wouldn't be able to do with a state trademark. So really, I mean, I can go on and on about the differences and things that are similar. Really what Yogesh is asking is, do I really need to go through the trademarking process on the federal level if I want to protect my brand, or can I just get away with maybe registering a state trademark, or maybe not even doing any of that and just registering my business name with the state? The answer is, if you think you'll be able to build a brand that matters for a business that matters, it should be a no-brainer. Go for a federal trademark. It's the only way to really protect your brand, and it's the only way to really build an asset out of your brand. So state trademark, registering in a corporate registry might give you this much protection. That would not be enough for anything if you're hoping to make that business, that brand so successful that it's worth protecting. So I hope this answers Yogesh's question, and if it does, great. I hope that you found something useful in this video as well. If you did, make sure you subscribe right now and get notified whenever the next video goes live. And if you've got a question for me, post in a comment below. I'll answer it in a video just like this one. And until then, I'll see you in the next video.